Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to start here with a hypothetical, and here's the hypothetical for you to consider today. I want you to consider that you have obtained a license in another state. Let's call it a marriage license. Now, whatever you did in that first state, the state that you got married in, and I don't care who you got married to or what their gender was or any of that, but you jumped through all of the hoops in that originating state to get your marriage license. And you are now a legally married couple. Congratulations. And then you decide you're going to move from that state where you and your significant other got married to another state. And once you move there, you realize that that state, well, they're not even going to recognize your license. As a matter of fact, the minute you move to that state, you and your significant other are no longer a married couple. You do not enjoy any of the benefits that come with being a married couple, and the law itself does not even recognize you as a married couple. Could that actually happen in the United States of America? And then what I want you to do is I actually just want you to change marriage license and take your significant other out of the equation, and let's just change it to a different right, like, I don't know, the right to conceal carry. Well, that might be one of the issues that's happening in a California case that I think has the ability to have huge implications. So today, let's slow it down for a little bit, let's geek out, and let's talk about the California case that could change concealed carry nationwide. Okay, so the case we are talking about today is California Rifle and Pistol Association v. Luna. It is a case that we have already geeked out on once before. It originates as a challenge to Los Angeles County's ridiculous delays in granting citizens their concealed carry permit. Now, since we're doing a video about California, I will remind everyone that we're going to do a shout out to our first ever California subscriber. Of course, that's Philip P. Philip P. has been subscribing to Washington Gun Law since we became a channel and has been spreading the gospel of Washington Gun Law down there. So Philip P., this one is for you. Now, as I mentioned on this video right here, we had already kind of geeked out about this case, and we focused extensively in that video about all of the crazy shenanigans that were going on both in Los Angeles County as well as the municipality of Laverne, California. There was a side note in that, and I said we were going to do a follow-up video, and this is the video that we're doing, which is there is also a challenge to the fact that, you see, unless you're a California resident, there is absolutely zero legal ability for you to carry a firearm outside of your home in defense of yourself or others. Okay, let me explain why, okay? We're going to talk about a thing today that we call concealed carry reciprocity. What is that? Concealed carry reciprocity is where you go to a visiting state and that state either does or does not honor your concealed carry privilege that you have from the state that you originate from. If it is honored, you get to carry in that state as if you were a resident of that state, consistent with that state's laws. Now, here's the thing about California and Hawaii, because they both apparently think that they are way better than everybody else, because only California and Hawaii, one, do not recognize reciprocity from any other jurisdiction in the United States, and two, do not offer out-of-state carry permits to anybody in the United States, regardless of their lawful status. Now, interestingly, there actually are 8 other states in the country that do not recognize concealed carry licenses from any other state. And those states include Connecticut, Illinois, Maryland, Massachusetts, New Jersey, New York, Oregon, Rhode Island, and the District of Columbia, which, as we like to call around here, the usual suspects. But you see, here's something different about those 8 compared to California and Hawaii, is that each of those states and the District of Columbia will actually offer you the opportunity to get an out-of-state concealed carry license. The state of California and the state of Hawaii do not offer in any way, shape, or form any out-of-state carry privileges, period. Now, this whole notion that you don't just lose your constitutional rights merely by crossing a state line is not unique to this case. Let us remember the case of Commonwealth of Massachusetts v. Donnell. Now, this involved an individual with proper New Hampshire carry privileges who was then in a shopping mall where part of that mall happened to lie inside the state of Massachusetts. In throwing out the indictment against Mr. Donnell, the court had ruled an individual only loses a constitutional right if he commits an offense or has been or is engaged in certain behavior that is covered by 18 U.S.C. Section 922. He doesn't lose that right simply by traveling into an adjoining state whose statute mandates that residents of that state obtain a license prior to exercising their constitutional right. To hold otherwise would inexplicably treat Second Amendment rights differently than other individually held rights. And then, of course, in addition to that, the judge found that there's absolutely no historical precedent at all saying that people magically then forfeit their constitutional rights by crossing a state line. Well, this exact issue is part of the pleadings in California Rifle and Pistol Association v. Luna in the challenge to the fact that all of these individuals who are trying to get concealed carry licenses in Los Angeles County or trying to get them in the municipality of Laverne can't go anywhere else to get them. They can't apply for an out-of-state, apply for a Nevada's concealed carry license, which would then give them reciprocity agreements with the state of California because, well, California doesn't do it. Or use an out-of-state address to get an out-of-state permit because, well, again, California doesn't do it. And neither does Hawaii, by the way. And so that brings us full circle back to the hypothetical that we started this video with, because let us remember that there was a case before the United States Supreme Court not that long ago. It's called Obergefell v. Hodges. And that is a case that basically stands for the proposition that gay marriage is a constitutionally protected right. But what were the facts of that case? Well, the facts of that case is that Mr. Obergefell and his domestic partner had gotten married in the state of Maryland. However, when they came back to their home state of Ohio, well, the state of Ohio was not willing to recognize that marriage. And so therefore, even though they departed the state of Maryland as a married couple, having been given all the rights and privileges by that state, having gone through whatever vetting process the state of Maryland required them to go through, the minute they got back into their home state of Ohio, they suddenly had lost those rights for no reason other than they had crossed into that state. The Supreme Court rightfully threw that out and basically stated that the state of Ohio was mandated to honor the marriage license that had been granted this couple in the state of Maryland. Why then does the state of California or the state of Hawaii believe that they have the right to limit the constitutional right of carrying a firearm in protection of yourself and others to only in-state residents? The plaintiffs in the Luna case specifically referred to the Obergefell case and drew the analogy this way. This holding and its logic with respect to an enumerated right apply just as much to the enumerated right to bear arms and thus applies equally to CCW permits issued by other states as the Supreme Court instructs that it does to marriage licenses issued by other states. California may not completely deny Americans the right to carry for self-defense within California's borders just because they are not California residents. And ultimately, does this lead to a situation where many people, predominantly down there in Los Angeles County or any other place that is playing games with your inalienable rights, does it force them just to go out and willfully violate the law? And do they do so with complete immunity, such as what we saw during the civil rights movement of the late 60s? Consider this quote from the United States Supreme Court. In the free speech context, an individual faced with such an unconstitutional licensing law may ignore it and engage with impunity in the exercise of the right of free expression for which the law purports to require a license. And of course, that comes from a huge civil rights case, Shuttleworth versus City of Birmingham, United States Supreme Court, 1969. And listen, this is really important because every year that they've been keeping data on this, California has ranked as one of the top 3 most visited states by people from around the country. So, as it turns out, this little case down there in Los Angeles, the one that's just sticking up for the concealed carry rights of millions of Los Angeles County residents and those in Laverne, California, actually has the potential to do something much greater than that. It actually has the potential to significantly and forever alter concealed carry laws throughout the nation. Why should one state get to willfully deny you a constitutional right that another state has already vetted you for merely because they don't like the address that's on your driver's license. Okay, so the case once again is California Pistol and Rifle Association v. Luna. We'll link it all up down below so you can geek out on the complaint for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.